So firstly, welcome everybody and thank you for joining us. This webinar is brought to you by the Garden Court Chambers Community Care Team. And today we will be discussing the law and practice issues emerging in respect of decisions made by the National Age Assessment Board, or NAAB, the Home Office body, which was introduced by the Nationality and Borders Act 2022, or NABA. So very briefly then, to introduce our speakers, we are without chair today. So first of all, I'm Nadia O'Mara and I am a barrister here at Garden Court Chambers, and among my practice areas are age assessments. Next up, we are really delighted to welcome Lisa Matthews, who is the Policy and Campaigns Manager at Young Roots. Lisa has led policy and campaigns at Young Roots since 2023, with a focus on age assessments, refugee homelessness, and the right to safety. And finally then, Eva Doerr, who is also a barrister and member of Garden Court and who, like me, practices age assessments. Lisa will be speaking first, then myself, and then Eva. So I will now hand over to Lisa. Thank you all.
Thanks very much, Nadia. I'll just now share my screen. Yes, so as mentioned, I'm Lisa, the Policy and Campaigns Manager at Young Roots. Young Roots works with young asylum seekers and refugees in London, young people between the ages of 11 and 25. And I'm going to be providing some context, some background to the National Age Assessment Board, because we know that not everyone will necessarily have encountered it. And I'm going to be providing some background to the kind of politics and policy around the NAAB, because we are seeing some of that feeding into legal matters as well. So, as Nadia mentioned, the National Age Assessment Board sits under the Home Office. I'm going to call it the NAAB from now on. And the NAAB was introduced by the 2022 Nationality and Borders Act, sections 50 and 51. It began initially as a very small pilot project with just a few local authorities referring to it for age assessments, and then was expanded to be a more national operation in March 2023. And the latest figures we have are that 71 local authorities are now referring age assessment referrals to NAAB. So why does the NAAB exist when the practice for so long has been for age assessments to be conducted, Merton-style age assessments to be conducted by local authorities? The Home Office guidance says that it exists to reduce the pressure on local authority resources and to improve child safeguarding by achieving a consistent approach to age assessment. And we have also repeatedly seen the phrase Centre of Excellence used by ministers about the NAAB. When the NAAB initially began, there were quite severe capacity issues which limited its function, and this was mainly because of problems recruiting social workers to work for it. No doubt mainly because the British Association of Social Workers were very clear in their opposition to their members and wider practitioners from being employed by the Home Office due to the ethical concerns around that and around impartiality. And they said at the time of the first recruitment happening that any agency that is part of the Home Office risks age assessments being influenced by political priorities as opposed to child welfare and human rights. Now, by February this year, the NAAB employed 53 social workers, which is a large amount if you think about the size of local authority age assessment teams, but it is still having to refuse age assessment referrals due to lack of capacity. So the NAAB exists, it's functioning. Why would local authorities use the NAAB? Because the majority of referrals to NAAB are coming from local authorities rather than the Home Office. Well, most local authorities will talk about the issue of resources, the fact that they have a big backlog of age assessment decisions that need to be made, which leads to delays, which obviously actually isn't good for young people concerned. They have a shortage of staff who are able or trained or willing to do age assessments. There is considerable discomfort about conducting age assessments. Partly this is due to the sheer impossibility of determining age definitively. There's concerns about the ethics of it, and there's genuine concerns about the kind of high stakes consequences of these decisions. And it's also worth bearing in mind that if a local authority refers a young person to the NAAB and the NAAB conduct the age assessment, if there's an illegal challenge to that age assessment, the legal costs of that legal challenge, if lost, are borne by the NAAB and not local authorities. So there would seem to be an economics case for the NAAB, but another angle on that is the sheer cost of the NAAB, which those funds could instead be used for local authority resources. So we know that in the first year of its operation, the NAAB cost £1.7 million. What we don't know is what it's cost since then. We can only assume that the cost will be much greater than that since then, because it was a very small operation in the beginning and has since expanded in terms of staff it employs. But when Jessa Sartu, the MP, recently asked in a parliamentary question what the cost of the public purse was of establishing and operating the NAAB, and if the minister will divert this expenditure into training social workers in local authorities, again because this idea that NAAB is meant to be a centre of excellence, the minister's response was that due to the operational nature of the NAAB, the costs are subject to change and are currently not published. So we don't actually have it currently on public record how much the NAAB is costing. In terms of what the NAAB is doing, in 2023, it conducted 21 age assessments and then 114 in 2024. So still not huge numbers. The numbers will be higher for 2025 again, but still not massive numbers. And from those age assessments, 61% of the young people were determined by the NAAB to be adults. And for a very rough comparison, kind of on average, local authority age assessments find roughly about 40% of young people to be adults. There's been some questions from Young Roots and others about how robust those NAAB assessments are, and we have sought to find out how the NAAB has fared in terms of legal challenges. But the picture is a bit murky, I have to say. We submitted via our local MP a parliamentary question at the same time as an FOI was submitted, and the response to how the NAAB was doing in terms of legal challenges was that the NAAB was subject to 22 legal challenges, and they successfully defended 20 of those 22. This was quite surprising, given the quality of some of the decisions we've seen and also just some of the anecdotal evidence we have about judgments that were found against the NAAB. And when it was followed up to find out exactly what the NAAB is meaning by successfully defended, they replied, in our response where we've referred to challenges that were defended, this is in relation to PAPs, where our position is to maintain our decision. So they always maintain their position in PAPs, which is the conclusion of the PAP. It should be noted that some decisions may yet result in judicial reviews being lodged. Now, it's not clear, but to me, this sounds like they are counting successfully defended as up to the PAP stage only, which, of course, is not a commonly shared definition of a successful defence of a legal challenge. We are seeking clarification on this through a further FOI, and we're also seeking the 2025 figures because, again, anecdotally, it seems like the NAAB probably hasn't fared very well in the most recent legal challenges. But yeah, worth noting that this is what the NAAB is stating as a successful defence, but also that their position is to not concede at the PAP stage. So one of the main policy issues for basically every organisation supporting young people who might be subject to these age assessments is whether a body that sits under the Home Office can be independent and can make impartial decisions on age. And we shared these concerns with our local MP, Natasha Irons, who also was concerned about this and asked a parliamentary question in which she asked the minister what assessment her department has made of the adequacy of the level of independence of the NAAB. And the minister replied, we have gone to great lengths to ensure that the NAAB is distinct from the Home Office's asylum and immigration decision-making functions, and the two sit under separate management functions. In addition, the information acquired by the NAAB when conducting age assessments is not accessible to asylum and immigration decision-making teams other than the final decision on age. Right, fair enough. But as BAFRA have said in response, age assessments should be undertaken impartially by social workers who are not part of the Home Office. A major role of the Home Office is immigration control. It's difficult to be impartial if you're employed by and line managed by an organisation with these responsibilities. It's not just young people's organisations and BASWA who have concerns about this independence, the recent Chief Inspector of Borders report on age assessment looked at this question of independence of NAAB, and inspectors found some blurring of the boundaries between asylum caseworking and the NAAB's age assessment work. Now, while NAAB social workers don't have access to the Home Office's caseworking database, the NAAB operation teams do, and frequently downloaded asylum statement of evidence forms and welfare interview records for NAAB social workers to refer to during their assessments. And you'll remember the Minister pointing out that the detail of age assessments done by NAAB are not made available to the asylum teams. Unfortunately, some people working for NAAB think this is a shame, and NAAB social workers reported to the inspector they felt it was a weakness that they didn't share their age assessment reports with other teams, because there was a lot of valuable information that could be used in an asylum claim during the age assessment, such as if a social worker believed a young person was not from where they said they were. So some quite serious and valid concerns about the lack of independence of the NAAB sitting under the Home Office. And given that, it's then also very worrying that there is just no independent oversight of NAAB age assessments. The only kind of level of oversight is at an internal level, kind of internal quality assurance. So it's the NAAB marking its own homework. And even with that mechanism, it's not doing particularly well. So in November 2024, there were 8 audit reports. 1 was rated inadequate, and 7 requires improvement. By January 2025, still the majority of the 7 audit reports required improvements. There's just one other final policy theme I'd like to flag before I talk a bit about what we're seeing on the ground in terms of age assessments from NAAB. And this is a worrying pattern of if young people are referred to local authorities and local authorities are confident that young person is a child and therefore don't conduct a full age assessment, which is entirely in keeping with guidance, best practice and case law, there has been repeat occurrences of the Home Office saying, well, if you don't do an age assessment, we'll get the NAAB to do it, which feels like a significant undermining of the professional independence of local authority social workers, and feels like a way of pressuring local authorities to do the Home Office's bidding. So the age assessments themselves, what are they like? Well, for a supposed centre of excellence, we are very concerned that what we've seen is that we have done research into decision-making of local authority social worker age assessments, and we released a report on that last year. And unfortunately, what we see is a mirroring of the poor quality decision-making we found through that in NAAB age assessments. And this is particularly around things like an over-reliance on physical indicators, the kind of really frustrating, offensive comments that are made about physical appearance and assumptions on age based on physical appearance, which it's very clear that physical appearance should not be overly relied upon because of how unreliable physical indicators are of age. And there's much kind of more reliable indicators, social development, independent skills. But again, there's this kind of defaulting to physical indicators, which we do see in local authority age assessments, but a centre of excellence should not be repeating that practice. And again, we also see this kind of negative credibility focus, the idea that if a young person says something that's inconsistent, kind of leaping on that and using that without actually kind of looking for positive credibility, and also any inconsistencies in general seeming to the assessors to indicate lack of credibility about age, where one doesn't necessarily follow the other. Young people's experience of NAAB age assessments have not been good. They have described them to us as being like interrogations, like their assessors are trying to trip them up. And this is absolutely echoed in the excellent briefing by GMIAU, which is linked to in the slides, where young people described what age assessments have been like. And they said they were trying to trap you. They were trying to confuse me and say I'd given a different answer, but I was sure about my answer. And I'm sure those of you who have any familiarity with Home Office asylum interviews will recognise that kind of approach to trying to trap people. So very worrying to see that in age assessments. And also a distinct lack of a trauma-informed approach in age assessments, where young people are being asked repeatedly about things they've said they're not comfortable talking about or not able to talk about. So it's a thumbs down from young people, and there's also, we have seen a lack of understanding of really important core principles of age assessments, including the concept of the benefit of the doubt, which was mentioned by a judge in the case that Nadia was representing. And we've seen in our practice a lack of understanding of what an appropriate adult is, who can be an appropriate adult, what they can do and what they can't do. And this is meant to be an essential part of an age assessment process. There's some rather strange kind of anomalies around some of the practicalities. So while a local authority refers a young person to NAAB for the assessment, the local authority retains responsibility for booking the interpreters, which doesn't seem to make any sense and results in lots of wasted time for local authority social workers trying to book, rebook, and deal with any issues around that. And we've seen consistent issues around quality of interpretation, bias being shown by interpreters, and I think more concerningly, from the NAAB's point of view, when a young person has tried to express that they're not understanding or that what they're saying is not what's being reported back to the assessor, or the question isn't making sense, they know something's going on with the interpretation, the assessor's just not understanding the concept of that, which again is a really basic part of conducting these age assessments. And I'll finish on the point that if any of you have been involved with NAAB cases, you will know that the NAAB are consistently producing extremely long decision documents. And while it's been noted in court judgments that long doesn't necessarily mean good, that's not necessarily a shared view by all. And there's lots of practical implications for those long decision documents. I mean, obviously, young people are not going to be able to find those accessible. But we've also noticed a pattern, not just at Young Roots, but other organisations have shared this as well, of the legal aid agency refusing legal aid for challenges to NAAB decisions, presumably on the basis, it would seem, that the long decisions must be comprehensive decisions, therefore no challenge would be likely to succeed, where that's simply not the case, as my co-presenters will now talk about. So I will stop sharing and hand over to Nadia.
Thank you so much, Lisa. That was extremely interesting and informative, and definitely reflects some of the issues that I have observed with these assessments so far in my practice, particularly that last point that Lisa raised around the length of these decisions and the kind of knock-on impact that has on the impression of quality and potential refusals in the first instance from the legal aid agency. I am going to speak to you about two topics, and if the Garden Court team could help by sharing my slides now, that would be great. So first of all, I will speak about probably the quite boring part, namely the statutory scheme under NAAB 2022. I will endeavour to keep this quite brief, and will really focus on the key operative sections 50 and 51. And then secondly, I wanted to touch on the topic of interim relief in JR proceedings for age assessments, where what we have now is with NAAB assessments, the defendant is the Home Office rather than a local authority, as those who practice age assessments would, age assessment challenges would be familiar with. Yes, so first of all, as many will be aware, age assessments are dealt with in Part 4 of NAAB. Some of these provisions listed are not yet in force, and some, such as the very dubious provision on the use of scientific methods, has been subject to amendment under the Illegal Migration Act. NAAB is the first time that anything to do with age assessments has been put on a statutory footing. The lawful approach to be taken by local authorities in determining a young person's age for the purpose of assessing whether and how to exercise functions under children's legislation has been governed exclusively by case law, along with various non-statutory guidance documents. I am, as I mentioned, going to speak mainly to sections 49 to 51, and then I know that Eva later is going to pick up on section 56 and talk to you about new information arising following age assessments. So firstly, section 49, which provides relevant definitions. Of relevance for our purposes is first of all the definition of an age disputed person and then of a designated person. So an age disputed person is anyone who requires leave to enter the UK. This does mean that it is wider in scope technically than only being concerned with US children. However, in practice, US children do and likely will continue to be the ones who are subject to these procedures. Then there is the definition of a designated person. That just means somebody that the Secretary of State has designated to conduct these assessments, and this is then where you get the NAAB from. So then on to the first of the two kind of key operative provisions, the first being section 50. Section 50 confers a power on effectively NAAB caseworkers and social workers to conduct age assessments following a referral from a local authority. So subsection 1 provides that local authorities may refer an age disputed person to the NAAB for an assessment. Subsection 2 then defines the circumstances in which actions required later under section 50, so subsections 3 and 4, the circumstances in which those apply. So first of all is where a local authority needs to know the age of an age disputed person for the purposes of deciding whether to exercise functions under children's legislation, and then they say, NAAB, can you do this assessment for us? Or, more concerningly, where the Secretary of State notifies a local authority in writing that the age of a person is disputed to whom a local authority has exercised or may exercise functions under the Children Act. So then just briefly thinking back to what Lisa was saying about bias, this is then a statutory provision which stipulates that when the Secretary of State is simply not happy with a decision by a local authority, it can then turn around and say, we don't really like your decision, so actually we're just going to make it instead. Then going on to section 50, subsection 3, this sets out 3 actions that a local authority must then choose to do one of following a notification from the Secretary of State. So firstly, that is to refer the age disputed person to the NAAB to conduct an assessment. Secondly, to conduct an assessment themselves and then to inform the Home Office of the results. And then thirdly, if the local authority is in fact satisfied that the young person is the age claimed and concludes an assessment's not required, then they must notify the Home Office in writing. Subsection 4 effectively requires local authorities to explain themselves when they've conducted an assessment and show their homework to the Home Office. Subsection 5 requires local authorities to help the NAAB with any reasonably required assistance for the purpose of the assessment. And this is where you get the tricky interpreter issues that Lisa mentioned, and the oddity of effectively local authorities being the ones required to organise interpreters for NAAB assessments. And certainly in my own casework, I have experienced some really quite problematic outcomes as a result. Subsection 6 then briefly stipulates that the standard of proof here is the balance of probabilities. I would note, however, that in my view, this does nothing to displace the fact that the burden of proof does not rest on the age disputed child, as we know from the well-established case law. I see no reason why this statutory provision should displace that. And then finally, Section 50 further provides that NAAB assessments are binding on the Home Office when they're exercising immigration functions, and are binding on local authorities when considering whether and how to exercise functions under children's legislation. Next slide, please. So then just moving on to section 51, this confers a power on the NAAB to conduct age assessments in specific circumstances which are not addressed by section 50, which include whether or how the Home Office should exercise immigration functions in relation to a person. So under section 51, the legislation provides for two circumstances in which the NAAB is permitted to conduct an age assessment under this provision. The first being at any time before a local authority has referred an age disputed person to the NAAB or conducted an age assessment itself. And secondly, if the Home Office has reason to doubt an age assessment conducted by a local authority or has reason to doubt a local authority's decision not to conduct an age assessment. And again, here we see the statutory underpinning of one of the other worrying practices that Lisa mentioned during her presentation. So assessments under section 51 are binding on the Home Office for immigration functions, but curiously, I would note that on its face, section 51 assessments don't appear to be binding on local authorities. So all I wish to flag on this slide is just to note that the provision which would create a statutory appeal right in age assessments has not come into force. I briefly then just wanted to flag the NAAB caseworker guidance. It is Home Office caseworker guidance, so it is absolutely not to be taken as gospel, but it is overall a helpful and detailed document, particularly for those new to age assessments or new to NAAB assessments, as it does give you quite a detailed overview of both the statutory framework, but also the sort of policy and practice in terms of the running of the NAAB. It is also guidance which NAAB social workers are expected to follow. So there can be, or it is worth having a read through, as there can be helpful nuggets which can potentially be relied upon in challenges to age assessments down the line. I also flag it at this juncture because it is a statutory provision that is addressed in the guidance. But while there are significant grounds of concern for the NAAB being part of the Home Office, there are a couple of slivers of benefit. And the thing I'm thinking about here is the fact that because the NAAB is part of the Home Office, the Section 55 duty bites on its officials, and so I think that's something for practitioners to bear in mind, that the best interest duty is at play here on a statutory footing. And then it appears to have fallen off my slides, but I also just wanted to flag the joint working guidance between the Home Office and the ADCS. Anyone that does age assessments will be familiar with the ADCS guidance document, but there is also a joint working guidance document, which is good to be aware of. Right, so then turning away from the statutory framework and briefly then to speak about challenges to age assessment decisions. I wanted to make a couple of general points and then speak specifically about interim relief, and then specifically about interim relief in NAAB cases. So at the outset, it is just, as I've already done, worth flagging that the statutory provisions in NABA, which would create an appeal right against NAB assessments, has not come into force. And so what that means is that as things stand, the only means of challenging a NAB assessment is the same as challenging a local authority assessment, which is through judicial review. And then in the event permission is granted, the cases will invariably be transferred to the upper tribunal for a fact-finding hearing on age. Interim relief is often an incredibly important aspect of age assessment judicial review cases. So where a young person has been assessed as an adult, whether by the NAAB or by a local authority, they will be taken out of local authority care, or as the case may be, may never have been looked after in the first place. Age disputed young people are invariably asylum seekers and are once they have been taken out of local authority care, are then placed in Home Office adult hotel accommodation. In these hotels, they are then expected to share a room with unknown adults, which gives rise to obvious safeguarding concerns. These unsuitable reception conditions can have a profound impact on young people's mental health, amongst other things. Never mind the loss of social worker support, access to education, loss of financial support, and so on. Many age-disputed children are on their own case, 16 or 17 years old, no matter how many times assessors are reminded by the courts that physical appearance and demeanour are notoriously unreliable indicators of age. It remains far more likely that older teenagers are assessed as adults for the obvious reason that they tend to look slightly older than younger teenagers. But this is a critical juncture, not only in terms of access to support as a looked after child, but also in terms of accruing the 13 weeks required in order to be eligible for care leaver support. All of which is to say, interim relief is very important in age dispute cases. However, it is also a very difficult balancing exercise, and it can be a difficult ask depending on the facts in an individual case. There are a ton of cases about interim relief in age assessments. And just for the purposes of today, I would flag two. The first being the widely cited authority of BG, and the second being what I find to be a very helpful Fordham decision in the case of KRA, where he does a very helpful job of summarising lots of the relevant case law, so we don't have to. So in cases where the defendant is the local authority, invariably the interim relief source has two parts to it. The first is that a young person be treated as their claimed age pending the final determination of that question at trial. And secondly, that the local authority support and accommodate that young person under children's legislation until the final determination of the question of age. Where permission to apply for judicial review is granted, whether there is a serious issue to be tried is unlikely to be a contentious issue. However, what I would emphasise is the importance here of the strength of the positive case, as it directly goes to the balancing exercise which the court will undertake when looking at the balance of convenience. And the strength of your positive case is highly relevant to that question. So that being the general frame under when seeking interim relief and your defendant is the local authority. But what about where your defendant is the Secretary of State? And I know that this is a point that Eva's going to cover, but for the time being, let's assume that when you bring a judicial review against the NAAB, the Secretary of State for the Home Department is your defendant. So firstly and obviously, they are not the public authority with responsibility for US children, that is local authorities. Therefore, in order to get a child back into the care of a local authority, it doesn't help much to seek an order in that respect against the Secretary of State. You cannot tell the Secretary of State to take a child into care. Furthermore, the young person may have been dispersed away from the local authority area where they were looked after. This will be quite common. Given the no choice basis of asylum support accommodation, it is highly likely that if a person is accepted as eligible for Section 95, they will be moved away from wherever they had been based previously. And this is where, again, it becomes slightly interesting that the Secretary of State is the body responsible for the NAAB, because of course they are also the public authority department with responsibility for asylum support. This came up in a case of mine not long ago. My client had been in, let's call it local authority area A for quite some time and had developed a very strong support network in that area while he was looked after. His placement and his college were amazing, and he had built up a lot of friends, and really he had a good sense of stability in that local authority area. He then went through a NAAB assessment and was assessed to be an adult, and then was put in section 95 and was dispersed just miles and miles away from local authority A in local authority B, and his mental health deteriorated and so on. My client had no interest in going into the care of local authority B. He really wanted to return to the care of local authority A if we were able to secure interim relief in the judicial review proceedings. And so the approach that we took to interim relief was, first of all, to ask that he be treated as his claimed age pending the final determination of that question. And then secondly, what we did was ask the court to order the Secretary of State to disperse my client back to the original local authority area using the Secretary of State's powers under section 95. And the benefit of this was that duties under the Children Act are triggered by physical presence, so being a child in need in the area of a local authority. And had we not sought to disperse, to seek an order dispersing my client back, then he would have been recognised as his claimed age pending final determination, but in this local authority area very far away. And it would be that local authority whose children's legislation functions were triggered by his physical presence. And so the benefit then of seeking an order that the Secretary of State disperse him back to the first local authority area was that would then trigger his physical presence in that area, and the status quo could be maintained because but for the Secretary of State's decision, he would never have been dispersed out of the area of local authority A. The court did grant the interim relief in the terms as sought. Finally, just in practice, I think what actually happened was not that the Secretary of State did the dispersing, but following the order, liaised directly with the local authority and arranged for him to be picked up by Children's Services, and has since been taken back into their care pending his fact-finding hearing. That was all I wanted to say, and now I will pass you on to Eva. Thank you so much.
Thanks very much, Bath. I have the next slide. So today's seminar, as you've heard, is meant to be about NAAB age assessments, but I'm afraid that really of the three short topics I'm going to be covering, only really the first is specific to age assessments conducted by NAAB, and the other two topics really just came out of an ongoing challenge of mine against an age assessment conducted by NAAB. So firstly, and Nadia briefly mentioned this already, I'm going to talk about who is the correct defendant in JR proceedings. Is it the Secretary of State or is it NAAB? Secondly, I'm going to talk about the new evidence provisions. And then lastly, I'm going to speak about a procedural issue in relation to adducing expert or new evidence into JR proceedings in the context of age assessments. So before I start with these three topics, I'm going to just briefly say something that I'm really curious about what your experience is. So in my experience, they are much less likely, the NAAB is much less likely than local authorities to settle claims, really at any stage of the process. And I'm really curious to hear what the reason for that might be, because I have cases where I think, you know, if this really goes to trial, and we had interim hearings that we've won, and I'm thinking if this really goes to trial, you know, I think we do have a really good chance of winning. And normally against the local authority, I would have definitely anticipated the case to settle before it goes to trial. But they seem to be digging in their heels and actually continuing the challenge. And maybe I found it really interesting listening to Lisa earlier, because maybe the reason is that they don't really want to admit to having to settle or being unsuccessful in challenges. So anyway, I'm really curious and very curious to hear your experience on it. So now going into my 3 issues. Next slide, please. So the first one is about who is the correct defendant. I didn't really think that needed to be a question, because I thought it was obviously the Secretary of State, and that is whom I ordinarily issue these JR proceedings against. And the reason is, or I think, it follows from the statutory provisions, because both sections 50 and 51 of NAAB empower a designated person to conduct an age assessment. And if you then look at the definition of a designated person under section 49 of that act, it says an official of the Secretary of State who's designated by the Secretary of State to conduct age assessments under section 50 or 51. Now, the issue has arisen because the Secretary of State, or NAAB, the defendant, appears to now, and there seems to have been some kind of change in policy, to regularly argue, and even at later stages in proceedings, where JR proceedings have been going on for some time, that the correct defendant is actually NAAB as opposed to the Secretary of State. And the reasoning that they provide, and I find it really curious, is somehow that they are arguing that, if I understand this correctly, that persons designated by the Secretary of State form the NAAB, and that is why they are not the Secretary of State. I mean, I must admit that I'm having difficulties following the logic, but I think the decision, or what I'm going to do now in my challenges, is just to push back against this reading of NAAB. And I think the best answer is that, section 49 defines a designated person as an official of the Secretary of State. So clearly the Secretary of State is the correct target of a challenge. And when we were just the 3 of us discussing before this webinar, what the reason may be, it's probably just because of trying to give the impression that the NAAB is actually independent of the Secretary of State rather than part of the Secretary of State. And that is why I think it's particularly important that we push back on this. And hopefully the courts will soon have something to say about this and we get some clarity. Moving on to the next slide and my next topic. This is about the new information provisions. So this is not really about NAAB age assessments, but really to make it sound more topical than it potentially is. I've included the statutory provisions in NAAB that relates to NAAB age assessments. Also because they're actually really quite difficult to track down. So I think Nadia mentioned earlier that I was going to talk about section 56 of NAAB. But that provision is very confusing. That provision is actually also not yet enforced, just like section 54 and 55, because section 56 also relates to the statutory appeals, and it will come into force as and when we may get statutory appeals determining age. So currently, there are transitional provisions in force which relates specifically to cases where an age assessment was conducted by NAAB. So really, you don't have to worry about these transitional provisions if you're dealing with an age assessment that's been conducted by the local authority, in which case it's still the provisions under the ADCS guidance. But the transitional provisions can be found in these regulations at the top of my slides there, It's Regulation 4 of these 23 regulations, and they include or insert sections 57A to 7C into section 57. And yeah, it's really interesting, or it's quite interesting, I think, to compare the provisions between those set out in the ADCS guidance and in NAAB. Now, what section 57A does, it allows the NAAB, so importantly, this is a power, not a duty, so there's no duty to reassess age after an initial age assessment has been conducted, where further significant new evidence emerges, but instead the provision allows NAAB to decide to carry out a further age assessment. So that's quite interesting, because if you look at the bottom of the slide, the guidance says that where any such significant evidence arises, then a new age assessment should be conducted. So it's really slightly watered down. And important as well is just to look at the definition of what significant new evidence is. So that definition is set out at section 50 of 7B of NAAB. And it says that new information is significant new evidence if there's a realistic prospect that if a further age assessment were to be conducted on a person, taking into account this new information, the person's age would be assessed as different from the age determined in the first age assessment. So I've actually found this provision quite useful in order to challenge age assessments conducted by NAAB, just because otherwise, what Lisa and Nadia have already flagged, they're often very, very lengthy. And public law errors are not so, in relation to, for example, Merton compliance, aren't as obvious. And so a little bit harder to convince a judge reading the papers, a permission judge reading the papers, that there are such errors. Whereas this provision is really quite helpful if, in your case, there has been new information provided by, for example, the individual after the initial age assessment has been conducted by NAAB. And I've recently used this case on the next slide that I found really useful. So in case, I just thought I'd mention it in case it comes in useful for any of your cases. So this issue recently arose in this case, MIA and Dorset Council. So this was not a NAAB case, so not a NAAB age assessment, but a local authority age assessment. So the provisions applied were those under the ADCS guidance. But this was a JR claim brought by an Afghan national, not of the age assessment itself, but of a decision not to reassess age in light of the person having provided an actual copy of their identification document. So here, in this case, the Tazkira, and also 2 expert reports confirming the authenticity of the document. And the judge, really, really useful, Mr. Justice Dye, held that actually the decision was irrational and unlawful. And I thought it was so useful because what he did is he applied this relatively new judgment on irrationality by Mr. Justice Chamberlain in KP, saying that there was both process irrationality, which I think is just so easy to show that it's made out in many of these cases, because the local authority just asked itself the wrong question when assessing whether they should reassess age. So rather than asking whether it was possible to reach a different conclusion on reassessment, they totally focused, and in my experience, they always do, totally focus on whether the age assessment was wrong. So whether the outcome of the age assessment was wrong. So I think it's quite useful because I think this case helps in many cases to show that there was process irrationality. But then he also really usefully said this, and it seems totally obvious to me, But I think it's a powerful line that has proven quite useful. That there was also outcome irrationality, and really it's just totally obvious because he says, standing back, it's in any event difficult to reconcile what's said in the original age assessment, even if it was carried out in accordance with the proper practice for doing so, with what appears on the face of the tazkira. That alone should, in my view, lead to the defendant looking at the matter again. So if your child or putative child finds or manages to get access to a copy of an ID document, then this judgment is just so super useful. And yeah, hopefully it will assist. And the court in that case then imposed a mandatory order requiring the local authority to undertake the reassessment of the claimant's age, taking into account this new evidence. Now, moving on to the next slide. Very briefly, my last topic of the day, and I'm really very sorry that it's a rather boring one because it's about procedural matters in relation to adducing new or expert evidence in age assessment JR proceedings. Again, this isn't really about NAAB age assessments, but I recently found a very useful judgment that I just thought would be useful to share with you. So generally, there's another judgment that was published recently in the case of MS and Kent County Council, where really the judge, it was an age assessment case, and the judge in that case just reminded us that it's really important that where expert evidence is relied on, you have to apply for permission from the courts to be able to rely on it. And you also have to identify as early as possible the need for expert evidence. So it's just a good reminder that we have to be careful, even in the age assessment context, where parties may readily accept new evidence as being admissible, that we do have to apply to the court for permission to rely on it. And so the other day I had it in a case that I was making an application to adduce new evidence that we'd obtained after issuing the JR proceedings. And I had to essentially argue. So this application was opposed, which I already couldn't believe, but I had to essentially argue why permission to adduce such further evidence should be readily obtainable in age assessment JRs. And I thought it was kind of obvious, but because the upper tribunal once permission is granted and the matter is transferred to the upper tribunal, the tribunal's function is then to determine age as a matter of precedent fact, that it's obvious that fresh evidence is absolutely key and is absolutely key is going to be absolutely key in that assessment, that it should also be admissible and any application adduced should be granted pre-permission. And then I found this really useful case by Mr. Justice Fordham in GB and Leeds County Council, where he just granted an application to adduce fresh evidence at the permission stage on the basis that it's properly part of the material before the court. It's part of the evidence which could properly be put before the upper tribunal at any substantive hearing. And so I just thought I'd share that case with you because I found it really useful to make that application to adduce further evidence. And on that note, I'm going to finish my presentation at 3 to 6. Okay, it looks like no one has any questions or any thoughts or concerns at this stage. So then I think it's really just for us to say thank you all for attending. And that's it, unless there's anything else.
No, thank you so much, everyone.
Thanks, everyone.
Thank you.